Hello friends. Today we will try to understand about the procedure of arbitration. Arbitration, as you all know, is a process of alternative dispute resolution system, and any dispute which can go to court, provided it's a civil dispute, it can also go to the arbitration. So, what's the procedure for arbitration, and what are the things which can arise within the arbitration mechanism? We will understand that. We will also try to understand few aspects with relation to what is an award of the arbitration and how that award is to be dealt with. So, let us start with our presentation. Uh, as I said, that dispute resolution can either be adversarial or non-adversarial. Now, what is adversarial? It is where the parties contest the claim and leave it to a third party or court to decide the dispute. In non-adversarial resolution, they come together and try to resolve it together. So it is non-adversarial is generally without the assistance of the third party, or it can be with the assistance of third party who is just mediating and bringing them together. So arbitration, now you would understand, that is a adversarial form of litigation, though it is not for the court to decide but for the parties to decide. So, adversarial mechanism of dispute resolutions are two, that is the litigation and arbitration. And non-adversarial mechanism would mean conciliation, when parties together sit together and reconcile their issues, or mediation. Mediation would mean where a third party is involved, but that third party will not try to say something or enforce something, but that third party will only be limiting its scope to bring them together and ask them to come to a solution which is good for both of them. So arbitration is an alternative dispute resolution mechanism which is adversarial in nature. However, court is not deciding the disputes within the parties, and it is left to the arbitrator appointed by parties themselves. If the arbitrator is not being appointed by the parties themselves, then in that case, Chief Justice of the High Court or Supreme Court has to decide the dispute with regards to the appointment of arbitrator, not more than that. So, arbitration is possible only when parties to a civil dispute agree to refer the matter to the arbitrator. Now, it has to be by way of a written agreement between the parties, and that agreement can be like part of the original agreement, or it can also be subsequent to the dispute arising that parties agree that they will refer it to the arbitration. So, they have to submit to arbitration all or certain dispute that have arisen between the parties. It can be even for the future disputes and in respect to legal relationship that they have. Now, judicial intervention is specifically barred. Now, Act provides for judicial intervention, but at only three stages. That is, one, before the arbitration begins, there can be an intervention by the court for granting interim measures. Now, interim measure means when the court decides that whether there has to be a status quo to be maintained or some stay on the work or anything by any of the parties, or what and in what manner the parties will perform till the time the dispute is decided by the arbitrator, who is yet to be appointed. Now, that can be the interim measures. Then there can be a setting aside of arbitral award. Now, once the award is passed, then we will come to it in the further slides. Award has passed under section 34. Act provides for the uh, method by which it can be set aside and under what provisions it can be set aside. So under section 34, there are very limited grounds, which very narrow scope under which the award can be set aside. And third, intervention is possible only in form of an appeal against the order of setting aside or non-setting aside of the arbitral award, or against the not setting aside or not granting the interim measures. So there can be appeal under section 37. Now, when a civil suit is filed before a court and court comes to a conclusion that there is a pre-existing dispute, arbitration agreement, I'm sorry, between the parties, then it shall refer the dispute for arbitration without further sitting on the dispute. So courts are not allowed to proceed under the with the matter if there is an arbitration agreement. Now for this, a party who is a respondent or defendant may come up with an application before filing a written submissions or written statement stating that there is an arbitration agreement, and along with an application for referring the matter for arbitration, the party has to uh, proceed with the copy of the agreement where the arbitration clause is there. Now once the court comes to the conclusion that there is an arbitration agreement between the parties which is competent to take up the disputes which are being referred to the court, then court shall refer the parties to the arbitration without further sitting on the dispute. Now, if there is any failure of appointment of arbitrator by the any of the parties, that is, if one of the parties doesn't accept or agree on appointment of arbitrator within 30 days of notice of arbitration, then the other party can approach, that is the party who initiates the arbitration can approach the High Court or the Supreme Court, as the case may be, for appointment of the arbitrator, and the Chief Justice or his designate shall, after hearing the application, decide as to who shall be arbitrating upon the dispute. Now, once the arbitrator is appointed, now it can be a single arbitrator or more than one arbitrator. That is, it can be, generally it is in odd number, or three arbitrators. Now, that appointment of arbitrator makes it an arbitral tribunal. Now, arbitral tribunal now is equivalent to court. It has all the powers of a civil court. It can even rule on its own jurisdiction. It can even rule on any objection with respect to existence of a validity of arbitral agreement also. Now, plea that the arbitral tribunal does not have a jurisdiction cannot be raised later than submission of statement of defense. So, party raising such dispute shall not be precluded from raising such a plea merely on the ground that party has participated in the appointment of arbitrator. So, if someone participates in the appointment of arbitrator, can still raise the issues with regards to jurisdiction, but that has to be before the statement of defense is filed. And if the arbitral tribunal rejects the said application, it can be proceeded with the arbitration and pass an award. An award can be challenged under section 34. So any such interim orders with regards to jurisdiction and all, they cannot be separately challenged at different stages. Now, arbitral tribunal may award interim measures in case during the arbitration process. Now, these are the interim measures which are during the arbitration process after hearing both the parties, where award is passed but yet to be enforced as per section 36. Now, there were some initial interim measures which were already granted, so they can be even continued after the award is passed, but not before, but before it has been enforced. Now, what is the process of arbitration? So once the arbitrator is decided, the tribunal is constituted. The first meeting of arbitration will take place where the process of arbitration will be settled, fees of the arbitrator, venue of the arbitrator, and language of the arbitration proceedings will be decided upon. Then comes the stage of filing statement of claim. That is, the party which has initiated the arbitration will file its claim. The statement of claim is just like a suit. However, it is to be filed in a manner that all the grounds are mentioned, facts are mentioned, the grounds are mentioned, and the prayer, what the prayer the party is praying from the tribunal. Now these prayers can be multiple on multiple issues, even on the issues which were not initially uh, disputed at the time of issuing the notice of the arbitration. However, all the claims with regards to the dispute between the parties are now to be raised before the arbitrator. You cannot leave any dispute for to be raised at a later stage. Then comes the statement, the stage of filing of written statement. Here the defendant now will have to file their own written statement. This written statement will be denying the grounds in the writ statement of claim, the facts of the statement of claim, and if there is any counter claim that the party pleads, that can also be raised within the uh, written statement. So that counter claim will proceed as a separate arbitration proceeding, and the applicant or the plaintiff before the arbitration tribunal will have the right to file defense to that counterclaim also. There can be decision on interim measures, that how the parties will conduct themselves in their relationship, legal relationship that was existing with regards to any business they are doing, or whatever stay is required to be granted, that can also be considered by the arbitrator. Then comes the stage of hearing and written proceedings. The arbitrator can conduct the hearing itself, can also record the evidence itself. It can also take assistance of court for taking evidence. Hearing and written, then there can be written arguments as well as written submissions in addition to the oral arguments before the arbitrator. Arbitrator can also appoint experts to report to it on specific issues that are to be determined by the tribunal. Now, arbitral tribunal will have to give award within 12 months from the date on which it entered into the reference, and that period can be extended for further 6 months. However, the arbitral tribunal will have to apply to the honorable chief justice or his designate judge for that extension, and on being granted that extension with the reasons recorded in writing, it can be extended for further 6 months. And then comes the award. Once the award is passed, the tribunal is not having any power to further decide on the matter, and the award attains the finality of the entire proceedings. However, arbitral tribunal will always make efforts to encourage settlement between the parties even during the arbitration process. In case the settlement is arrived at, then the award that is passed by the arbitration tribunal shall be called a settlement award, and it will be in the terms of agreement between the parties. The award can also fix interest and costs which are payable to or by the parties in the arbitration process. Now, award is not appealable and therefore it is final. However, Section 34 gives the provisions under which the award can be set aside. It can be on the ground that any of the parties were under some incapacity during the proceeding. Number two, arbitration agreement is not valid under the law. If court comes to a conclusion that this arbitration agreement itself was not valid, then it can set aside the award. Third ground can be the parties not given proper notice of appointment of arbitrator or of the proceeding. So in case of lack of the notice, it can also be set aside. Next ground can be, it deals with the dispute not contemplated or not falling within the terms of submission. So if the dispute which has been brought forward before the learned arbitrator, that dispute is not even contemplated in terms of submission, in such case also it can be set aside. If the composition of tribunal or the procedure that was adopted was not as per the arbitration agreement. Now this is very important because arbitration procedure can be also be decided between the parties. So they may follow the procedure given under the Arbitration Act, or they may not follow the procedure and they may decide on their own procedure. So if that is also not followed, on that ground also this can be set aside. Now, last ground is the court finds that dispute is not capable of settlement by arbitration and award is in conflict of public policy of India. Now, what is public policy of India? When making of an award was induced or affected by fraud or corruption, or was violation of section 71, 5 or 81, or was in contravention of fundamental policy of Indian law, or it was in conflict with most basic notions of morality of justice. What is morality or justice? The morality or justice would have a very wide meaning. This has been discussed in some of the judgments. I will take up those points when I take up another uh, lecture on the discussing the judgments of Arbitration Act. Now, for domestic awards, there is one more ground which is available, that is a patent illegality appearing on face of award. Now, if something which is patently illegal, this can be a ground for setting aside domestic awards, but not for international awards. Because in international commercial arbitrations, you don't have this ground available. Award cannot be set aside on ground of erroneous application of law. This cannot be a ground, or by reappreciation of evidence. So the court which is sitting on the application cannot set aside the award on the ground of erroneous application of law or by doing reappreciation of evidence. Courts cannot look into the evidence again. Cannot, if there is two conclusion possible, one which is taken by the arbitrator and another which the court may arrive at after looking into the evidence, then the decision which is taken by the arbitrator will be considered to be final. Court cannot overturn that. Test as to whether there is a contravention with fundamental policy of Indian law shall not entail a review on merits of dispute. So merits cannot be looked into by the court, which is to set aside the application. Now, time limit. Now, under section 34, there is a 3 months from the date of award for date of decision on application under section 33. Now, after that, does the court have power to condone the delay? Yes, but that is only for 30 days. Once the time limit of 3 months is over, if the application is made within 30 days thereafter, the court can condone the delay with reasons to be recorded in writing. Now, beyond that, after 30 days, there is no power for condonation of delay. So, further delay, even of a day, cannot be condoned by the court and the award becomes final. Now, section 36 talks about enforceability of award. Now, this provision was amended in 2015. Earlier, whenever an award was passed and section 34 application was made, there used to be an automatic stay on the award execution. However, now the provision has been changed and the award is enforceable as if it's a decree of a court under CPC. Now, even if the application is filed under section 34, there will not be any automatic stay, and an application under section 36 subsection 2, section 36 subsection 2 has to be made. That will be uh, as a prayer in an interim application to the court to stay the execution of the award under section 36(2). Then comes the appeals. Now, appeals are only maintainable against three different orders: section 8, not referring the matter to the arbitration by the court, in spite of there being a condition of arbitration in the agreement itself. Section 9, that will be for interim measures denied or granted by the court, and section 34, that is setting aside or non-setting aside of the award. Now only in these three cases there is a first appeal which is maintainable, and there is no question of second appeal. Still, the Supreme Court can, under provisions of special leave petition, that is under Article 136, look into the orders passed by the appellate court. Now there is a new provision which has been introduced in the Act from 2015, that is Section 29B. This is called fast track arbitration, which is a new initiative. Now many cases there are issues which are not required to be decided on base of oral evidence, but the documents itself are speaking for themselves, and it can be decided on the basis of those documents. So parties can agree for a fast track procedure of an arbitrator shall have to give a award within 6 months from entering into reference, and parties have to submit statement of claim and defense along with all documents in their possession with respect to the dispute. Arbitrator can call for further information I'm sorry and documents after going through the statement of claim and defense, and hearing will only be provided if some party makes a request for it or the arbitrator finds it's necessary, and the technical formalities with regards to evidence, civil procedure, they can all be dispensed with. So this becomes very fast track procedure of arbitration, and the arbitrator will be only be mostly looking into the document affidavits, statement of claim, statement of written defense, and the documents there too, and on the basis of that will decide the matter.